Mr. Chairman, members of the committee, this concurrent resolution, if you look on page 1, lines 31 through 36, and on to page 2 there, it's the guts of the resolution. It provides the legislature hereby applies to the Congress under the provisions of Article 5 of the Constitution of the United States for calling a convention of states limited to proposing amendments to the Constitution of the United States that would impose fiscal restraints on the federal government, limit the power and jurisdiction of federal government, and limit the term of office of federal government members of Congress and federal officials. So anyway, if you have questions, there was a similar concurrent resolution introduced in the House, and it was debated on the House floor, I think, a week or so ago.
I believe, do you know, let me see what the resolution of the House, do you know how many voted for and against? I'll have to look on that one.
I think it was 77, but I'm not sure. We can look it up.
Okay, thank you, Mike. Any questions, committee? Senator Fausto.
Thank you, Mr. Chairman. And Mike, you don't look like Jason either. So you said that it would impose restraints. So what is currently allowed or not allowed to the contrast of that? Thank you.
Well, you would have this convention, and the convention then would have to come up with specifics, and that's the issue, what specifics. So it would be up to the convention, similar to the convention, I guess, that established the Constitution in the beginning back in the 18th century, 17th century.
Any other questions? Seeing none, thank you, Mike. What I'm going to do is we'll give each side 15 minutes total. If you don't need it, don't take it, obviously. And that way we'll have time for questions for the committee. We have our single oral testimony and proponent testimony from Michael Ferris, who's the co-founder and senior advisor of the Convention of States. Mike.
Mr. Chairman, members of the committee, my name is Michael Ferris. I am honored to be here today, and thank you so much for the opportunity to testify. Just a quick note of clarification as I begin. The House vote that took place last week was on the term limits resolution, which is slightly different than the one that we're proposing. So I would like to begin by just giving you a little history of Article 5, but even before that, I'd just like to preface it with a little bit of my background. I'm one of the few lawyers in the country who's actually litigated an Article 5 case. When the Equal Rights Amendment was originally proposed, it was given 7 years for ratification. Congress purported to change that by a simple majority vote about 6.5 years into that process. And shortly after that vote was taken, I represented 4 Washington state legislators who filed the original challenge to the constitutionality of the extension of time on the ERA. My case was consolidated with a case that was filed a couple weeks later by legislators in the states of Idaho and Arizona. And we litigated together, and the federal district court ruled that the process of changing the rules of the ratification process was unconstitutional. Once the rules are made, you stick by the rules. It was the basic holding of that. The case timed out then. It was accepted by the Supreme Court of the United States, but it was never argued because the second deadline passed and 38 states did not ratify within that time period. So the case was vacated as moot, but the record is you can't change the rules in the middle of the process. I also have taught constitutional law for 17 years at Patrick Henry College and have litigated, I've argued 2 cases in the Supreme Court of the United States and in the courts, the appellate courts of 13 states and 8 of the federal circuit courts of appeal. So I've been an appellate constitutional litigator for most of the 45 plus years I've been a lawyer. Why we have Article 5 in the fashion that it is came from a motion that George Mason made in the final week of the Constitutional Convention in 1787. The proposal on the table at that point in time was all amendments had to be proposed by Congress and all had to be ratified by the states. Mason stood up and said, and I'm going to paraphrase obviously, look at guys, someday the federal government is going to abuse its power. And when that happens, Congress will never propose an amendment to limit its own power. And so we've got to give the states an ability to start the amendment process. And so the record of the convention says that Mason's motion to make that amendment was agreed to nem con, which means without debate, no dissent. And so everyone saw the self-evident truth of what he was saying, that we need to have an opportunity for the states to run rather to protect the powers of the people and the powers of the states against federal abuse and federal overreach. And so my wife and I have 10 kids, and so I know something about raising kids. And it's like you have a kid and you never discipline until they're 18 or 19 or 20 years old. You got a mess on your hands. Well, we've never used the power of the states to discipline the federal government in 200 plus years. And we've got a mess on our hands as a consequence of that. The states have, state legislatures have the unique authority, the lawful authority directly from Article 5. You do not derive your authority to act in this from the Kansas Constitution or the Kansas laws. You derive it straight from Article 5 of the United States Constitution. And with that authority comes the moral responsibility, I suggest, to use it. And so the question really before us is the federal government out of control or not? And I would submit that it is. The debt alone is a great example of how it's out of control. There are many other examples, and I'm going to give two examples here in just a minute in particular to explain what could be accomplished by this process. But just one quick explanation of the process itself. 34 states, that's 2/3 of the states, have to vote to approve a convention for a particular purpose. There are hundreds and hundreds of resolutions out there that are still in effect and on the books, but we've never got to 34 on the same subject. And so we're well over 34 if you could just have anything would count. It doesn't work that way. You have to be on the same subject. And so the 19 states have enacted the resolution that's before you now verbatim in the operative section. Not the resolving clauses, the whereases and so on, that changes from state to state, that's fine. But in the actual language, it's been done exactly the same every state. And the reason for that is, so there's no argument about aggregation. If you have it exactly the same in every state, then it clearly aggregates. When 34 states do that, there must be a convention. Congress is given a role, but it's a ministerial role. They have no discretion in the process. They must call a convention. So then at the convention, it's one state, one vote. There's some people that like to say, well, where does it say that? And the record of every intrastate gathering in the United States history is one state, one vote. It's happened in multiple conventions of various kinds over the years, not an Article 5 convention to be sure, but various conventions. But even more common examples, Kansas is a party to 40 state compacts. And every state compact has either exclusively one state, one vote. That's the vast majority. Some states, some compacts have, like the Education Commission of the states, every state has an equal number of representatives, and so they vote as individuals, but you start off on the basis of state equality. It's only the interstate lottery compact that has a slight variance on the theme. There has to be 2 votes. It's basically a bicameral process there, and it's one state, one vote on one vote, and the other it's proportional based on the amount of lottery sales. And so that's the only exception. So the convention of 1787 was one state, one vote. Stage 1 is 34 states, one state, one vote. The ratification process is 38 states, one state, one vote. It will be one state, one vote at the convention itself. So it takes 26 states to vote for a proposed amendment. The amendment has to be germane. Our proposal says to impose fiscal restraints on the federal government, term limits on federal officials, not limited to members of Congress. It could be bureaucrats, it could be judges, it could be anybody that's a part of the federal government. And then impose jurisdictional limits on the power of the federal government. And I'll give you a couple examples of that in just a second. I do want to address, I know that one of the witnesses on the other side testified in the House I was remote that day, but he was in person, talks about the nature of the 1787 convention, supposedly as a runaway. You can find a lot of opinions about that on the internet. You can read blogs, you can read Facebook comments. My comments on this are published in the Harvard Journal of Law and Public Policy. And you can find that for free on the internet, but it's a peer-reviewed law review article. And it's called Defying Conventional Wisdom. If you go to a search engine and put my last name, Farris, F-A-R-R-I-S, and the phrase Defying Conventional Wisdom, you can read the article in full for yourself if you'd like. But I'd like to just briefly summarize why there's a lot of misinformation out there, and if the testimony stays true to the House side, you'll hear misinformation in just a few minutes as well. But I'll tell you the straight story first. The myth that they were only supposed to amend the Articles of Confederation, but instead enacted a whole new document, comes from a misunderstanding of a resolution passed by Congress in the midst of calling the Article 5 Convention. The process actually began with the Annapolis Convention. They got together to talk about how to fix the commerce problems they were having. They were only authorized to talk about commerce, and they quickly discovered that they didn't have enough authority to talk about the things they really needed to talk about. So they were so concerned with their lack of authority, they adjourned the Annapolis Convention, went back to their states. They proposed a format for the next convention, but they knew they had to get authority from their states to do it. And their request was to be authorized to, and I'm quoting, render the federal constitution adequate for the exigencies of the Union. And so Virginia was the first state to call the Philadelphia Convention of 1787 using that exact phrase. A total of 6 states enacted that exact phrase, appointed their delegates, gave them their instructions, and at that point, Congress endorsed the process. And in the process of endorsing it, they said only amend the Articles of Confederation. It's the legal equivalent of a National Pickle Week resolution today. It's their opinion. Thank you very much for your opinion, Congress. They never even sent it to the states. It was not the call. There was a very clear process. When they wanted to send something to the states, they voted on not only the body of the measure, but a transmittal letter was voted on. And there was no transmittal letter. There was no vote on a transmittal letter. There's no record of it ever being sent to the states. And when the delegates got together and debated their authority, and they did debate their authority at the Constitutional Convention, they always referred to their instructions from the states. That's who gave them their authority. With the exception of New York and Massachusetts, their instructions were, in Connecticut, it was almost exactly the same as Virginia, but the ones that really differed were New York and Massachusetts. They all said, render the federal constitution adequate for the exigencies of the Union. When the delegates of New York saw that they were going in a different direction than they had been authorized, they thought, they left. Hamilton stayed. He never voted again because the New York rules required all 3 delegates to be present. So there was no runaway whatsoever at the convention. They followed their rules explicitly. Now, there may be discussion about the ratification process. There were actually 2 documents sent by the founders from this. The first document was the Constitution. The second was a measure relative to the ratification process. They sent it to Congress. Congress unanimously approved the new ratification process and sent it not to the state conventions that approved the Constitution, but to the state legislatures. All 13 state legislatures, including Rhode Island and North Carolina, that originally either delayed or rejected the Constitution, all 13 legislatures voted to approve the new process by calling a ratification convention. Rhode Island's was the most interesting because they named all their citizens as the delegates to the convention and basically held a plebiscite and voted down the Constitution initially. But all 13 states approved the new process. So anybody that tells you that it wasn't done by the right process and it was a self-authenticating doesn't know their history. And I invite them to go read my article in the Harvard Law Review, Harvard Journal of Law and Public Policy, to be precise. Now, what can be done to fix the problems that we're facing? Take the $1.7 trillion bill that passed in December, supposedly a spending measure, all kinds of other things, or electoral college reform, all kinds of things jammed in this bill. If that was subject to the single subject rule that 41 states have in their state constitution, that would have been about 100 bills. Now, you wouldn't get enough floor time to get all 100 up, so some of them would have died by that process. And some of them would die because they would not be popular. And so the ability to pass these massive bills that nobody happens could be fixed by simply adopting a federal single subject rule that would be germane under the call that we're proposing. One other example that's pending right now. The Biden administration has proposed, along with the World Health Organization, a new treaty. And that new treaty would transfer from every state the ability to regulate the pandemics the way the states wanted to regulate it to the federal government with the oversight of the World Health Organization. I have an LLM in public international law from the University of London, and I can tell you as a matter of treaty law, that's exactly how it works. The treaty responsibility is required to be enforced by the federal government, not by the states. And so if you transfer jurisdiction of pandemics from the states to the federal government through a treaty process, it will be the president, not the governors, making these decisions. Worse than that, President Biden intends to ratify this through the executive agreement process. We've divided our treaties up. No other nation does this. And under international law, there's only one document. It's called a treaty. But the United States, for a long time.
Mike.
Okay, thank you. You could fix this problem and make every treaty be ratified by the Senate. Rather, right now, there's about 5,000 treaties that the Senate never voted on because of this end run the Supreme Court's approved. We can clarify that, eliminate all those executive agreements unless they're re-ratified by the Senate. And that's the kind of cleanup that we can do. It's impossible to pass something crazy. It's really hard to pass something good through this process. To get 38 states is really hard. Unless it's clean, pretty straightforward, it's not going to get ratified. And so anybody that thinks that we can lose the Second Amendment or the First Amendment or anything like that is simply not looking at the way it works. 38 states must ratify. The idea that we can get something crazy through that process simply is untenable. I would urge you to take your responsibility that the Constitution gives to you and call a convention so that we can restrict the abuse of power by the federal government. Thank you.
Thank you, Mr. Ferris. We will have you stand for questions afterward. We'll have the opponents talk, and then we'll open it to both sides. By the way, committee, we have 16 proponents who have supplied written-only testimony for your review. We have no, are there any other, well, I guess our 15 minutes is up. So we have no neutral testimony. Are there any who would like to provide neutral testimony? Seeing none, we'll move on to our oral opponent testimony. And again, we have two. John Axtell is up first, and then Blake Branson second. And I will similarly give you 15 minutes to apportion it how you see fit. And up first is John Axtell, Kansas Campaign for Liberty. John?
Thank you, Chairman. I'm John Axtell from Wichita, and I'm the volunteer coordinator for Kansas Campaign for Liberty. And Honorable Chair and members of the Senate Federal and State Affairs Committee, I'm here to oppose SCR 1607. Let's start with the Convention of 1787 and just take a look at data. Now, the proponent gave a long explanation, but I'm just going to look at data. I'm a retired engineer. That's what I do. If we look at what the delegates themselves said about the convention, we see William Patterson, a New Jersey delegate, saying, "We ought to keep within its limits, or we should be charged by our constituents with usurpation. Let us return to our states and obtain larger powers, not assume them ourselves." He's very clear that that the convention, according to his mind, was about to exceed its authority, and he wanted them to stop and return to the states and get the proper authority before proceeding. And even James Madison in Federalist 40 states clearly that in one particular, it is admitted that the convention have departed from the tenor of their commission. Instead of reporting a plan requiring the confirmation of all the states, they have reported a plan which is to be confirmed and may be carried into effect by 9 states only. Now, in my written testimony, I give several other cases of delegates who wanted to stop and thought that they were exceeding their authority, other delegates who wanted to proceed but also thought they were exceeding authority. What you won't find is delegates who felt they were doing exactly as they were ordered. That's just data. It's irrefutable. It's not lots of words. It's just data. Now, we don't need to look back 230 to 240 years to the Convention of 1787 to see the evidence that the Constitutional Convention process will not be controlled by the state legislature. We see this unfolding right here, right now, and showing very clearly that a convention, quote, cannot be constrained by the people of Kansas. Proponents have set the stage to sue the state of Kansas or the Constitution in federal court in order to make it easier to pass this resolution. And we've seen in the House Rules Committee how that stage was set, with the amendment to change the rules, as it was stated by the proponent bringing the amendment, to make the language consistent with the Senate rules and to accommodate a lawsuit. Now, that's essentially what that proponent said. And that amendment did pass. And the wording in this resolution regarding the requirement for passage is consistent with that plan and with those rules in the House and in the Senate. Therefore, a vote for SCR 1607 is a vote to sue Kansas. Now, the proponents who want to see this lawsuit happen are relying on federal courts which have said, for example, in the Dyer versus Blair decision, that a state legislature can consider their state's statutes and constitutions and so on to be precatory. Now, that's a word I had to look up. It means just a wish and not enforceable when applying for the Constitutional Convention under Article 5. Now, these federal courts have said the reason for that is because the state legislature is operating under federal authority, strictly federal authority, when calling for a convention under Article 5. And therefore, they have no responsibility to their state's constitution, its statutes, or whatever under this authority. So if the state legislature operates in a strictly federal role, or authority when applying for this convention, certainly the delegates, when attending a convention, are also operating under strictly federal authority. And therefore, if the members of the Kansas legislature who would vote for this and vote for the lawsuit can turn their backs on the Kansas Constitution and essentially participate as rogue agents under strictly federal authority, then certainly delegates attending the convention can do exactly the same and can ignore this Kansas Constitution, Kansas statutes, and any directions from the Kansas legislature. They are operating within the same authority. So finally, I want to point out that no conflict exists between the state constitution and the federal constitution. You see, in Dyer versus Blair and other court cases, in no case that I've seen did the federal court order the state legislature to violate the state constitution in order to be in compliance with the federal constitution. Now, had that happened, you'd be forced to do so, and that's not precatory then. The Kansas Constitution, it's not precatory, it's a violation of the federal constitution, but the courts have said it's precatory. They've never said it's a violation of the federal constitution. So you have the opportunity to honor the Kansas Constitution and honor the federal constitution, and in fact, Dyer versus Blair said exactly that. Where this conflict is that would take this to a federal court for adjudication, where this conflict is between the proponents who would take this to court and the Kansas Constitution. It's between the proponents and we, the people of Kansas. So a vote for this resolution is a vote to sue Kansas. And it's a vote for a constitutional convention that, quote, cannot be constrained by the people of Kansas, end quote. I urge you to vote against SCR 1607. And I'll leave the rest of my time for the other opponent. Thank you.
Thank you very much, John. We have 7 minutes, well, 8 minutes left. And our next oral testimony comes from Blake Branson, and Blake is on WebEx. Blake, are you with us?
I'm with you. Can you hear me okay?
Yes, Sean, turn him up just a pinch so we make sure everybody can hear him clearly. Okay, go ahead, and I'll start the clock again. You've got about 8 minutes, Blake.
Thank you. Honorable Chairman and members of the House Committee on Federal and State Affairs, or Senate, I'm sorry, Senate Committee on Federal and State Affairs. I wish I could support this resolution. The problems we face often feel overwhelming. Everywhere we look, there is a controversy. There's controversy, corruption, and more of our liberties slipping away. It would be so nice to have an easy solution to solve all our problems, and it would be much easier to stand alongside so many of my proponent friends, both inside and outside of the legislature. But the Constitution is too important, and the problems with this resolution are too numerous for me to do so. An Article 5 convention in today's climate would end in either disaster or a giant waste of time. The problem we face is that the establishment politicians don't follow the Constitution, and we the people, the grassroots, have a hard time holding them accountable. Unfortunately, term limits doesn't solve this problem because entrenched politicians aren't all we have to contend with. These politicians build large and powerful organizations, and that is what the grassroots needs to contend with or rival. I go into more detail in my written testimony, but term limits doesn't solve this problem. Only by learning to build and organize well enough to hold politicians accountable can we solve this problem. As for other potential amendments beyond term limits, we face the same problem. If we don't learn how to hold politicians accountable, what will stop the politicians from ignoring the new words we put in the Constitution the same way they ignore them now? Another problem I have is with the wording of this resolution itself. If you talk to any grassroots proponent of this resolution, they will tell you that this resolution would limit the convention to only a couple issues. But this resolution specifically doesn't do that. SCR 1607 states that the topics or issues of the convention include to, quote, impose fiscal restraints and, quote, limit the power and jurisdiction of the federal government, unquote. So what does this mean? It means that so long as a fiscal restraint or a limit of power is included in any proposed amendment, even if it is mere showmanship, every part of the Constitution and every issue is on the table. This resolution doesn't successfully do what proponents want. Proponents also have the faulty assumption that harmful amendments will be obvious or controversial. The amendments proposed that will be most dangerous won't be the obvious ones. It might be an amendment that simply contains loose language that leads to unintended results, or it might be an amendment that would change the rights protected by our Constitution. Proponents will also tell you that the states will protect us from bad amendments, and that ratification is too high a hurdle for bad amendments to come about. But how well did the states protect us from COVID shutdowns? How many states have policies now that would be disastrous if they were simply codified into our Constitution? 49 states were shut down during COVID. 38 plus states have Medicaid expansion. Nearly every state has some form of gun rights restrictions. Nearly every state has Common Core or CRT of some sort. So imagine for a moment what policy in this country might look like if 12 states that most align with your political ideology disappeared. Imagine what the country would look like if the Constitution were altered to reflect that. 12 states can be left entirely out of the equation, and an amendment that changes the Constitution can still be ratified. Kansas might be one of those states left out of the discussion. Additionally, we don't know who the delegates will be. I've seen delegate bills in different parts of the country where delegates are selected in all sorts of different manners. Some elected in a normal election, some selected by state politicians. there's a lot of questions around this, and each state might do things differently. So just because we do the right thing here in Kansas doesn't necessarily mean that the rest of the states will do the same. So I ask, do you trust these states with our Constitution? I believe that if you consider it carefully, you will find there are at least a few issues that you care about passionately, where trusting other states to change the Constitution would be a nightmare. Instead, I encourage you to partner with grassroots activists by being faithful to your oaths and holding your colleagues and other elected officials accountable for their actions and to the Constitution. I strongly urge you to oppose SCR 1607. Thank you for your consideration.
Thank you, Blake. Committee, we also have one opponent who has supplied written-only testimony, and that also is available for you online. So at this point, I'd like to open it up to questions for either the proponents or opponents from the committee. Committee, do we have any questions? Senator Holscher and then Senator Fasquedo.
Thank you, Mr. Chair. Yes, I'd like to ask a couple questions of Mr. Axtell, if I said your name correctly. Thank you.
Thank you.
You mentioned that when a convention is called, it operates under federal authority. And as I read through the documents, that's what I keep seeing popping up in the Constitution and the various articles. Can you tell me, is that due to the supremacy clause, or is it because of a different part of our Constitution that says that when the convention is called, it operates under federal authority?
The Dyer decision, the Dyer versus Blair decision is what I'm going off of. And it simply says that, well, I can probably bring it up here for you. It does not address the question of supremacy because it's not germane. First of all, it says it's not an issue of supremacy again, because supremacy would have invoked that idea of forceful enforcement of the federal Constitution and calling the Kansas Constitution or the state Constitution to be in violation. That's when supremacy would be invoked. Does that make sense?
Sure does.
So it's not the right, with all due respect, a question of supremacy is not the right question to ask. Okay, with all due respect, and
Yeah, no, I get
I need
it.
to be respectful.
Yeah, no, and I realize in Article 6, Clause 2, Article 1, Section 8, both of those point to the fact that, again, once the convention is called, it operates under federal authority. I have a follow-up then. Do you have any information in regard to the one state, one vote information that's been shared?
I don't have that with me, but I have read and I think you'd call it an opinion. I don't know exactly what the kind of document would be called, but it's by the Congressional Research Service, and it was from, I believe, 2014. They talked vaguely about what they saw Congress doing with regard to calling the Constitutional Convention and the delegates. And I recall seeing in the Congressional Research Service's report that they would allocate delegates and votes to the states commensurate with or consistent with their allocation in the Electoral College. So bigger states would get more votes, smaller states would get less votes. It wouldn't be strictly by population, but it would be, of course, emphasized by population to a certain extent. That's what is in the Congressional Research Service's report. There was also a bill that didn't make it through Congress, but did go through the Senate, I believe. It was passed in the Senate, that would have had the same kind of effect with regard to delegate allocation in a constitutional convention called under Article 5.
Very good. Yeah, because my understanding is 1964, the Supreme Court required that it's proportional, sorry, that's hard for me to say, that it's proportional representation by population. So being a smaller state as far as population-wise, like we are in Kansas, our representation would stand to be quite a bit less compared to other states, through what was decided in 1964. So thank you. I appreciate the information.
Senator Fasquedo.
Thank you, Mr. Chairman. My question is for Mr. Ferris. So in the resolution on line 2, so the proposing of amendments, would they just be to add amendments or take any away?
It would be, an amendment could amend some portion of the Constitution that exists today, but it'd have to be a restriction on federal power. So, for example, judges are appointed for life. And if the term limits measure was adopted that said judges get 12-year terms, that would be operated as an amendment to that portion of the relevant text.
Okay, and Mr. Chairman, if I may, on Mr. Harris on line 2 or 20, so you mentioned 34 states and 40 states. Explain that contrast again, please.
Sure. There are 3 stages of the process. Stage 1 is setting the agenda. That's what you're doing right now. It's what are the subjects that are lawful to discuss right now? And it's 34 states will vote, one state, one vote on calling a convention. And when there are 34 that vote for the exactly same thing, then you have a convention limited to those topics. The next stage is 26 votes. Contrary to what the Honorable Senator said a moment ago, the 1964 case was about state proportional representation in the state legislature, not about an Article 5 convention. It's totally irrelevant. And the argument that you're under federal jurisdiction at that stage leaves out an important word. It's constitutional. You're under the jurisdiction of the federal Constitution, not under the jurisdiction of the federal government. There's an important distinction there. And so not everything that's a law of Congress is the same as under the Constitution of the United States. You get your authority to the way you hold presidential elections, not from the Constitution of Kansas, but from the Constitution of the United States. It says that state legislatures shall determine the methodology for choosing presidential electors. It's exactly the same. And the scare tactics that could work here could work exactly the same there. No, every state decides how you hold presidential elections, state by state. And you choose that method. Now that all the states have effectively done almost exactly the same thing, although Nebraska and Maine have carved out winning congressional districts so they divide up their electoral votes. So you can do things like that at the state level, but it's just simply not correct to say you are under federal, meaning congressional control. No, you're operating under the Constitution of the United States.
And Mr. Chairman, Mr. Ferris, I can tell you are an attorney because you can, without taking a breath, and I got all that, what you said. And then finally, so the term limits.
Would write what are the amendments that are proposed. So we're at the agenda setting stage right now. What can the states talk about? And when the states get together, they can agree on whatever it will be. If I had to guess, having been in a whole lot of state legislatures at this point in time, I think term limits will be one of the hardest things to get through. And so I don't know, but I don't think anything short, any kind of short-term limits of any kind will get through. But the exact details of any amendment would be worked out at the convention. And then it comes back to you to be ratified. And 38 states have to ratify.
Thank you, Senator. Senator Straub.
Thank you, Mr. Chairman, and thank you, Mr. Ferris. This question's also for you. I completely agree with you that term limits is probably the most difficult thing to accomplish, although over 70-some% of the general public support term limits on both sides of the aisle. So my question is there a process specified in Article 5 for suspending the rules of a convention, or is it simply stated that the states that are part of that convention will determine the rules?
There is no discussion of the rules in the text of Article 5 because conventions were so familiar to the founders that they understood that it would operate under the same basic assumptions. And that is, when you come, you listen to the authority given to you by the delegates. And by the way, the information that was shared to you about the delegates saying they were violating their instructions, just simply not borne out by the full record. And citing somebody's opinion is not a data point. A data point is votes and numbers and so on. There was cherry-picked opinion pieces. If you read the full record, those are cherry-picked and not representative of the truth. But the rules would be established by the delegates at the convention. You would come with instructions from your states. And so every state came to 1787 with instructions on how to vote. New York said all three members of the convention had to be there in order to vote. Other states had different rules on that, and everybody followed their own state rules. And so Kansas, what our hope is that there will be a model set of rules that 26 states will give their delegates instructions ahead of time to say, these will be the rules that you will enact. Those are not yet enacted, but that would be done at the time when you're appointing your delegates to send them. So we're a little bit ahead of the process to be able to do that now, but every place I go, every place absolutely wants one state, one vote. That's the most important rule. It would have to be a one state, one vote to change that, and small states are not going to let the 12 or 13 biggest states do that to them. It's just not going to happen. There are way more small states that would be disadvantaged by that, and so no convention worth its salt would ever make that vote.
Thank you.
Senator Blasey?
Thank you, Mr. Chairman. Just kind of, Mr. Ferris, kind of going off of Senator Holster's question for Mr. Axtell. What would your take on the selection process of delegates in terms of proportionality and all that? Do you have anything to add?
Every state can decide how many delegates you want to send. Virginia sent 7 to 1787. New York sent 3. It's one state, one vote. They don't physically caucus, but the way they counted it at the convention in 1787 was, like 4 votes for Virginia were yay, and 3 votes for Virginia were nay. So nay. So Virginia voted yes on that particular item. So it's like a mini caucus on every vote. That's how it would take place. So my recommendation is you would send 5 or 7, a manageable number, odd number. But it would be, you set the terms, you pick the delegates, the authority, 100% of the authority lies in the legislature. There have been cases about, do governors play a role? No, governors don't play a role. Why? They're given no role in the text of Article 5 of the Constitution. Can you do the ballot initiative process? No, because there's nothing in Article 5 that does that. Legislatures, state legislatures, you control your delegates 100% of the time, and anybody says the contrary is either trying to mislead you or really doesn't understand it.
Senator Pack, then Senator Holscher.
Thank you, Mr. Chairman. One question, I think it's fairly simple. I think I know the answer, but Mr. Ferris, I will ask you, if there is a convention of states, there is a convention, there are multiple amendments proposed by the convention. Each one stands or falls on its own as it relates to the 38 states, correct?
Correct. Just like the Bill of Rights. 12 were sent out, 10 were ratified initially, and what was originally the First Amendment got ratified 200 years later.
And then my second question, there's been very intelligent men like Mark Levin, who originally was an opponent to a convention of the states, but he later came to realize that it would be a good thing. From your perspective, have you ever been on the other side where you were someone who was concerned about a runaway convention, and then you, in looking at all of the parameters, realized that cannot happen, so you are now a proponent? And I've heard you speak multiple times, Mr. Ferris. I've always appreciated, enjoyed. Go ahead and take a breath every so often when you speak.
It's those time limits that push me that way. But what I was on the other side is I thought that the original convention in 1787 was a runaway. And then I decided to do a research because I realized that if I thought that, how do I call myself a constitutionalist in good faith? If it was a runaway and illegally adopted, why shouldn't I be out there campaigning saying, well, we should really be governed still under the Articles of Confederation? Because how do you be a constitutionalist and think it was illegally adopted? It just didn't make any sense to me. And so I dug in, and it took me about 4,000 hours of research I read every document of all the ratification conventions. I read every line of every version of the minutes of the convention. I read the Federalist Papers, the Anti-Federalist, I read everything, all the records. And the truth was really pretty clear at the end of the day. And so I was on the other side of that. I always thought that despite that fact, it was a good idea to go ahead and call the convention. But when I learned that, it just doubled my resolve that you can't do this improperly, because I was a very young lawyer when I was litigating the Article 5 case on the ERA. And I went to the National Archives, held every ratification document from the 13th Amendment forward, the original documents in my hand to deal with an issue we were dealing on that case. And so I've been a student of Article 5 for almost 50 years. And I'm convinced that this is the way, the only way we're going to solve Article 5. And the idea that they won't obey amendments is just not true. I mean, we have problems with the 11th Amendment, fixed stuff, we obeyed that. The 13th Amendment fixed things, we obeyed that. The 19th Amendment says women could get the right to vote, and we follow that. So the idea that if we amend the Constitution, nobody will obey with it, it just start listing off the amendments and look and see if we obey them or not, and you'll find out you aren't appointing your senators anymore because we obey the 17th Amendment. If we amend the Constitution, we obey it. And so let's amend the Constitution with a single subject rule and with another, a rule on the treaties, like I was suggesting earlier, a few other things that would be great to get the federal government the idea that they have people are watching them and make sure they stay within their enumerated powers.
We're just about out of time. One quick question from Senator Holscher.
Thank you, Mr. Chair. For clarification, you're with COSA, correct?
Yes.
And what groups is that group affiliated with?
Well, not official. There are others that have endorsed us, but I don't know what you mean by affiliate.
COSP, is that the project? Are those?
Oh, well, okay. There's a 501c3 and a 501c4, and I'm here on behalf of the C4.
Okay. Who funds those various groups?
There are thousands and thousands and thousands of donors, and we've been accused of taking money from George Soros, which is, flat lie. He funds the people that are openly opposing our efforts, including Common Cause and many others that oppose us.
Okay, yeah, the reason I ask is because I've gotten a number of emails, and when I call the people back and ask them that they're talking about term limits and reining in debt. Obviously, on the state level, we can pass laws that have an impact in those areas. Same thing as far as Congress, too. When I tell people that this is in regard to a constitutional convention, they say that they weren't aware of this tie-in, that this is an application for COS. And while they are concerned about term limits and spending, they're concerned that they have been, I guess misled is maybe the best word, that they have been sending emails to people asking for something else. And I cite cases in Ohio too. There were
Big question, because we are literally out of time.
Yeah, so like I said, that is my concern. Why not just do bills to do term limits?
Because you have the Supreme Court of the United States has ruled that state legislatures cannot enact term limits on federal officials in their state.
Yes, but we could enact them on ourselves or Congress.
No, you can't do them on Congress in your state.
No, we as a state legislature can enact them on ourselves. Congress can enact them on the Congress.
Congress cannot enact it by a bill on themselves. Congress would have to propose an amendment to change the Constitution of the United States. And so it takes 2/3 of both houses of Congress. Anyone who thinks that 2/3 of both houses of Congress will pass anything that limits their powers is living in a dream world. It won't happen.
Thank you. Thank you all. We are out of time. We will close the hearing now on SCR 1607. Committee, we make sure to turn in your packets to Sheila. Just as a administrative note, we will not have meeting on Friday. And then we've got a full week ahead, and so check your agendas on that. Thank you all.